I'm here with IP expert Kirk Sigmund. If you've seen any of the videos recently or any of the articles come out recently that reference IP expert weighs in on this topic, it's probably Kirk Sigmund. He is a lawyer that works at which law firm again?
It's called a Banner Wyckoff. Yeah.
Banner Whitcoff. Would you go ahead and introduce yourself and to steal a term from your profession, voir dire yourself to my audience about why you are an expert in this and why we should listen to you?
Sure. My name is Kirk Sigmund. Like you said, I have been practicing IP law for well over a decade at this point. Technically, if you ask on the four corners of it, I'm a specialist in electrical engineering and computer science patents. What that really means is that I do all forms of IP involving technical stuff that involves video games, AI, you name it. I have the fortune of having been involved in some of the fun stuff out there. So a very long time ago, I started in Tokyo working on that Apple Samsung case. Nowadays, I work on everything from video game patents to, like I said, AI type stuff. And I have been working in the video game space on and off, either confidentially or directly, for that decade. So I've been always involved. I mean, hell, I've played video games my entire life. That's kind of how I learned to read. So it's something that's always interesting to me, and I try to involve myself where I can. So I'm also the editor, or rather an author of Patent Arcade. I'm a published author in various forms of video game IP issues. So I'm kind of controversially wrote an article about 2 years ago about copyright and Nintendo and decompilations and things like that. So I've been doing this for a very long time, and needless to say, I do have a bit of a reputation for casting aspersions towards Nintendo. We'll call it that way.
I'm certain to get that reputation myself, so I think the audience will vibe with that a little bit. With that, well, I'm going to weigh in on one of the things you said. I was going to leave it to a little bit later, but you got your start in Tokyo. I saw on your page that you
Yep.
got your start in Tokyo. So to the people that are trying to say things like, "Well, he doesn't know what he's talking about," that this is Japanese law, this isn't American law. You know what you're talking about. That's how you started your legal career was in
Yep.
Tokyo.
And us IP guys, we do interface across the board. Like we're constantly working in different areas. So I do a lot of
Mhm.
European patents, for example, things like that. And granted, we're not certified in each other's regions, but we work together a lot. So there are
Mhm.
nuances about Japanese argumentation that certainly might be novel, but in general, we're very familiar with each other's law because we got to deal with it on a daily basis.
Yeah, I would imagine with something as wide reaching as IP law that you kind of have to be familiar with the law of all the places that the IP is going to exist
Oh
in.
yeah. Yeah.
Yeah.
There's always little
And
differences, and that's half the way we make money is like, hey, we need to know how to interface
yeah,
your same idea in like Canada, Europe, Japan, Korea, you name it.
yeah. Yeah. And you speak Japanese, you're learning Korean, so you actually understand the law as it is written to a little bit more. I took a semester of Japanese and the only thing I can say is watashi no hanashimasu nihongo desu, which means the only thing I can say in Japanese is a lie that I speak Japanese.
That's all you need. Like when I've been
Yeah.
over there, it's amazing how little Japanese I use. And I feel guilty about it. I'm like, it's
Mhm.
fine. Like I haven't studied in a bit anyway, so I could probably use a refresher, but I don't have to use it over there anyway.
Yeah. I've seen a lot of like YouTube commentators talk about when they go to Japan, they speak fluent Japanese. They took 4 years of it. They took Japanese history in college and blah blah blah. And the people over there is like, we speak English. We can speak English to you. It's
Because they
fine.
want to practice. They really do. Like half the time it's
Yeah,
like they want to get their English in. So it's like, all right, fine.
yeah, yeah. So when I initially reached out to you, I reached out to you because I was starting a campaign that my goal was to file PGRs and IPRs, post grant reviews and inter parts reviews, against the Nintendo patent specifically as a way to kind of fight back. We a lot of us have seen them, a lot of us have looked at them. I've looked at them as a layman that doesn't understand the legalese that's being spoken here as much, but with the hope of getting them devalidated so that they can't be used in a lawsuit in the United States eventually. Because there's a fear going on that okay, even if they lose this lawsuit in Japan, they might carry it over to the United States just to keep the pressure on.
Yep.
Um, but with that you were the one. I'd previously stated that if this doesn't work, if the PGR IPR process doesn't work, the next thing I'm going to do is start a database of prior art that can be used as, at the very least, to fight patent trolling in the future. Uh, and then I reached out to you and I said, "Hey, would you look at helping me with this PGR IPR process? I see you in the news a lot lately." And the first thing you said is, "Well, whoa, whoa, don't do that." But I got an idea for you. I got an idea for you. If you started a database of
Yeah.
prior art, and I was like, "Oh, okay, well, that's kind of galvanizing
Turns
for
out,
plan
yeah.
two, yeah. And that's a much cheaper option than the potentially $250,000, $500,000 process of filing a PGR and IPR against Nintendo's patents. Uh, so can you go ahead and explain why the PGR IPR process is probably not the best thing to do right now?
Sure. Yep. So I'll give you a high level of like a little bit of the history behind it so everyone kind of understands where this is coming from because things have changed dramatically in the last year in a way that has, people call it the patent bar. It's scared the crap out of everybody because things have changed so dramatically and so quickly that it's changed everything we're doing strategically, quite aggressively. So, long story short, and I'm generalizing here very aggressively just to kind of tell the story. So, over the last decade or so, there has been a recognition at the USPTO and even in Congress that we might have allowed too many patents. And that's to some degree true. I mean, there was a period where they realized, holy crap, there are tons of what they called business method patents. So patents directed to like investments and things like that, albeit
Hmm.
filtered through the concept of a computer. And they go, well, wait a minute, we never meant that to be something allowable. So as a consequence of which, ultimately there was this thing called an IPR invented. And there's also what's called a PGR, and at the same time there was what was called a business method review. All of them basically boil down to a way in which you could go as a petitioner to the patent office and say, wait a minute, y'all should have never granted that. And it would kick off what would essentially be a mini trial in front of a board of specialty judges who would go, okay, well, let's evaluate this. You'd have to surmount certain hoops. You'd have to prove your case. You'd have to come in. In the case of IPRs, you are limited to printed publications. Whereas in PGRs, if you're quick to file, they're similar, but you can also make other arguments as well, such as what we call 101 arguments. And business method reviews would allow you to basically challenge anything on any grounds just because it happened to relate to business methods. Either way, you're going to the government and saying, y'all should have never done that. And it was very powerful because there were many flaws with this system. And candidly, I think that it was a double-edged sword because on one hand, you created a system whereby bad patents could be essentially mini re-adjudicated to get rid of them and invalidate them if they were bad, and that was the goal. The problem with that is that at the same time, it became a weapon for those who wanted to bully smaller competitors who didn't really have the war chest that other people do to go in and attack their patents early just to throw a wrench in the machine, right? They'd come in with dubious prior art. They would have very good lawyers and they would be able to invalidate patents that probably should not have been invalidated. Or if they were to be invalidated, that probably would have better be a better domain for district court litigation. So what ended up happening was in the last year, there has been a general feeling across the board that this is a double-edged sword, and we're not really sure how this is playing off. But B, and I think perhaps more importantly, we don't have enough judges and enough staff within the USPTO to service this. Because remember, these are government employees. The USPTO is self-funding; they make tons of money on this, but they were overwhelmed because so many people found this as an adequate venue to either, again, get rid of a bad patent or to go bully a competitor. So ultimately, they got swamped. And what ended up happening was the USPTO comes up with what they call different terms. There's various things. They had a memorandum come out saying, well, from now on, we're a little bit overwhelmed. We need to manage our docket, which is something that judges can do in any context, right? They can kind of control how things are scheduled and everything else. But they say, look, we're now going to consider various factors as to whether or not we want to discretionarily deny your right to file an IPR because we instead want you to go to district court, say a summary judgment act or a declaratory judgment action, or just wait until you get sued, and then you can go handle it there. And as a consequence of which, this has dramatically changed everything because it turns out that little memo that everyone went, okay, sure, whatever, manage your docket, they have been rejecting under these discretionary grounds so many petitions, despite them paying, I think it's $23,000 in fees and probably spending $100,000 plus in attorney's fees. They've been saying, no, 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 we're not going to do it. We don't feel like it.
Hmm.
That's a big deal. And as a consequence of which, I think the statistic now is somewhere between 60 and 70% of applications, rather petitions, don't make it past either discretionary denial or just institution phase. They just don't make it past. So
Yeah.
if you're the lucky 30%, great on you. Realistically, this means that your chances are worse than, a coin flip of actually getting past that stage on spurious grounds such as, well, you had settled expectations between each other because the patent was out for some time, so you can figure it out in litigation.
Hmm.
This has made it very unfavorable for most people who would otherwise have filed a petition a long time ago. And as a consequence of which, most folks who are looking at IPRs are kind of scared off of it because it once was this valuable tool to go after a patent you didn't like. Now, given that you're spending so much money and you're not guaranteed much of anything, you might as well just wait to get sued, or you might well use some other venue, right? There's other options
Yeah.
there. So it's really radically changed in the last couple of years.
Yeah. Designed as a tool that was almost meant to help the little guy, but then the big guy very quickly found a way that we want to make the thing that you patented, but you have a patent for it and you can't afford to fight us on this kind of thing. So that same sort of lawfare, but now transitioning not into the civil court, but into the patent office, which is a different court system from my understanding.
Oh, absolutely. And I'll give you an
Yeah.
example. I mean, the ultimate good example of this, and I've worked on these cases myself. I used to work on these all the time, was, what people normally conventionally call a patent troll, but what we sometimes call NPEs, non-practicing entities. They'd come out of the woodwork with some old technology from the 90s and they would threaten to sue you on it. And then, you go, well, that's a bunk patent that should have never been granted. So you go to the IPR process to find relief. You find your way to get out of this by saying, no, that patent's junk. This patent troll should go away. And it was a valuable way to gum up that process. These NPEs would have to run away. I mean, they would still fight it, but it was a good way to handle that without having to go into litigation. The problem with this is it was also, like you said, used as a way to punish people. Like there were multiple instances in which, again, I won't disclose them, but certain clients of mine, they were smaller, nimbler competitors who ended up discovering things and patenting things and doing very cool stuff. Well, needless to say, the second they really begin to challenge the big companies, those guys come out of the woodwork and immediately hit them with IPRs on
Hmm.
weak grounds, but sometimes they won, which means that if you're a small guy, this could be a really big problem for you because then suddenly your patent's gone and they have essentially the right to go use your stuff. So
Yeah.
it was a double-edged sword. There's a good side to this calming down. At the same time, it was valuable for getting rid of bad patents. We do want it kind of back.
Yeah. Just need to probably change the process for it and change the methodology in which it can be implemented so that it can't be used in an abusive manner.
Bingo. And that's
And
hard,
yeah,
but you know.
yeah. And I feel like to my personal kind of thought on it would be, and I don't know, I always say there's the world we want to live in, and then there's the world we live in, and you have to fight for the world you want to live in, but recognize the world you live in. You could come up with a perfect plan, but then human nature takes over, and there's going to be a loophole. There's going to be some sort of way
Oh yeah.
to overcome that, unfortunately. Um, and I don't know what that would be. I don't know. I don't
Nobody
have an
does.
answer
I
to that.
mean,
Yeah.
this is an area
Uh,
where you have some of the really sharpest attorneys. All of us by law have to have at least an engineering degree of some kind or a science degree. Everyone's working like crazy to figure out how to balance this out, and it's just there's too many
mhm.
factors, right? I mean, notwithstanding trying to get this balance correctly of rewarding the good guys while punishing the bad guys, you have this issue of even if we do that, if we hit the right balance, that doesn't mean other countries are doing that. So
Yeah.
now you've got this issue where we might be completely correct, but that doesn't mean that you're not going to have similar issues pop up in China and Japan and Korea and everywhere else. So
Yeah.
we have to kind of match them a little bit so people have roughly equal protection, and that also sucks. So it's much more complicated than people want it to be.
Yeah, and on that grounds of settled expectations, because that was one of the first things I saw when I saw the PGR IPR process when I was trying to do research into okay, what can I as a layman do to kind of help out. The first thing I saw was the Proxysense versus Intel decision that was made, I believe, back in June of this year,
Yep.
where they said you've owned this for 9 years. They've had this patent for 9 years. Uh, they have settled expectations of having this patent. You can't fight it anymore, which is almost essentially saying crime is legal as long as you get away for it long enough. Which is, I guess, is the concept of statute of limitations: is crime is legal as long as you get away with it for long enough.
I suppose.
Uh, yeah, it's an unfortunate state of affairs. Um, I'm not at all condoning crime. Don't do it. But but with that, like, is there any sort of guidance on when that settled expectations comes in? Because with these things, okay, so you have 12 months to 18 months if they have a good reason for them to come back with a decision on an IPR or PGR. And the process itself takes a long time. Another lawyer I spoke to said with the man hours and with the time it would take, it would be $250 to $500,000 to file a PGR. And
Easily.
that's with overwhelming amounts of evidence that we could potentially have. Um, so that's a time consuming process. So even the process of getting to that point, is there any sort of guidance on when they're deciding there are settled expectations, or is it just kind of up to the judge and up to the acting director? I can't remember their name, but the acting director to decide
It's the
settled
latter.
expectations versus not settled
The
expectations. Yeah.
unfortunate side is nobody knows. It was funny. I was
Okay.
recently at a conference in Palo Alto where everyone was joking around going, well, none of us have a damn clue what this means. I mean, you're right. There's a statute of limitations vibe to it where there seems to be this implication that if you sit on things long enough, eventually they become sort of fixed in stone,
Hmm.
which there's a reason for this. So big companies do have the ability, the time, the money to actively monitor what their competitors are doing in the workplace, right? So, for example,
Hmm.
they'll watch patent grants from their competitors. That's something they've done for years because you do kind of want to know what other folks are doing, and ideally, if in under certain circumstances when you're not sort of inviting liability in that way, you do kind of want to have an idea of where they're going strategically as well as what you don't want to be doing. At the same time, small guys don't do that. People don't pay attention. The patent office is beleaguered with patent applications, much less granted patents. No one's able to do this. So this weird fantasy that somehow someone owning a patent for a number of years somehow grants it a mutability is silly because candidly we know for a fact that especially 10 plus years ago the standards for granting these were in some ways in some domains much more lenient. So we almost know for a fact that some of them are going to be junk, to be blunt. At the same time, that doesn't change anything with respect to what we would consider prior art domains. So, for example, just because something is 15 years old does not mean it was new just because it's 15 years old, right? The fact that it sits in someone's war chest and they didn't touch it for 15 years does not mean that when the application was originally filed, that was new. In fact, oftentimes what happens is that if they know that it's not particularly strong over what they perceive to be the existing prior art, they won't use it for a very long time because they know that it's subject to sort of challenge. So it's a very interesting dynamic that none of us really fully understand. But suffice to say, none of us are a big fan of it because we want at least certainty, right? If the board were to say our standard is 5 years, sure, okay, fine. It would be silly, and there's many arguments against it, but that would be fine. If we're being pragmatic and sort of realistic, likelihood is that what's being done is they're checking the ones that they think should go to litigation and just saying, y'all know each other for a while. You go figure this out in the district court.
Yeah.
There's a place for that. There's a time and a place, but calling that settled expectations a little bit silly.
Yeah, it's very much a situation, especially for some of these smaller creators, for some of the young inventors, or for the people that are creating things that don't necessarily have the force of a law firm or an in-house counsel behind them. They don't have the ability to check those things. And I
Nope.
recently checked some of the patents that have been filed by Nintendo. Just because I'm looking for content. I'll be honest. I'm looking for. Let's talk about something.
Let's be
I
real.
want to be the first to something for once. Which has been one or two times I was the first to something. I was like, yeah, let's go.
Yeah, powerful, right? Yeah.
Yeah. And at one point I saw just within a 30-day period they had filed 20, 30, 40 patents.
Oh,
So
easily.
it's not easy to keep track of these things, especially for someone that's not their full-time job and someone that doesn't know how the USPTO's database. I'm sure it's easier for you to use. I watched videos. I read a research paper
Oh God, I'm sorry.
on how to use that database. I don't know how to use it. I'm using the basic search and hoping it works. um, but it's very much one of those things where it seems like it's built for the big guy, not the small guy, to an extent.
Oh,
But
absolutely.
on that grounds, you mentioned 10 years ago, you mentioned that things used to be a little bit different 10 years ago. And one of the things that I noticed just going through patents, I did a video where I looked at 30 different video game patents and determined like, okay, does this actually seem like it's unique or does this seem like they're patenting an idea? Like let's throw an object that has an effect on a field character. Like, okay, so the
Yeah.
first caveman that threw a rock is prior art to that to an extent. Um, but a lot of them 10, 15, 20 years ago were written in kind of a plain speech that might have a little bit of legalese and a little bit tech jargon in there, but that's to be expected with a patent. It has to be technical. It has to explain to someone familiar in the arts how to recreate the thing. So there's going to be some tech jargon in there, but it was understandable. The average person with, a basic high school level reading comprehension would be able to read it, understand it, interpret it, and know what it's talking about. Some of these new ones say things like a transitory storage medium
Yeah.
wherein blah 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 have 30 claims to them, and each one of them is when in part the person of the it sounds like you're reading Beowulf almost.
Yep.
And are difficult to understand. Is there a reason why the language has transitioned so hard, or is that just a factor of these companies trying to make it either more confusing or more specific, or in some way? Is it a decision on the companies, or is it a decision on the way the USPTO is working
So half
and
and
what they're
half. I'll
expecting?
address the easy one first. So there's an element of some of this where those of us in the computer science, electrical engineering side of things, we did have to use over time develop specific terminology for things to kind of address concerns with the USPTO and also describe what we meant more clearly. And what I mean by that is a good example that computer readable media, oftentimes it's non-transitory computer readable media storing instructions thereon that when executed by one or more processors cause XYZ. The reason why that exists is because you are effectively trying to describe instructions as stored on some form of memory. But what happened was over time, the USPTO and courts would express concern about the fact they didn't want it to be ephemeral transmissions in the air. So, for example, just like signals. So
Hmm.
when you're trying to say, using I guess more 90s and 2000s parlance, like I want to claim the software on the CD, the disc, whatever. That's kind of how you would do that, and we still do that
Hmm.
today to describe the unmoving data as encrypt, as compressed, encoded, whatever, for various reasons. One of the reasons why, of course, is that we would want to be able to go after someone for selling your idea on software, even if you can't prove someone's run it, among other things. So there's a domain of that where it does actually, it's just us using very complicated terms that have, decades of history to them. However, you're absolutely correct to say that over time, what has happened in this area is that folks have begun to use much more convoluted terminology. And what's happened really, in my view, at least in some ways, is that they are so paranoid about getting hit with what's called a subject matter eligibility rejection that they try to bury what they would consider to be the more abstract, sort of high level concepts in what sound like technical steps or what sound like convoluted steps. And there's two
Hmm.
advantages to that. One of them is you bury it enough computer-ish sounding, technology-ish sounding terminology, so you ever so slightly increase your likelihood of an allowance on 101, or at least, them not hitting you with a rejection on 101. Because US 35 USC 101 basically says that you can't get a patent directed certain things. That includes, abstract ideas, and you don't want to look like an abstract idea. So that's one area of it. More particularly, and I think in many ways what we're seeing out of some of the patents that you've been reviewing, there is a strategy you can pull, which I don't do and most people don't do, but you'll see it out of some folks where they know that video game stuff and computer stuff tends to be very hard to search at the USPTO. So they have their own search system for finding what they call prior art. So that would be, fire printed publications, sales, everything else like that. The blunt reality is that for video games and for certain forms of software, it's very hard to find stuff like that because it's not as well documented as you would think. They're used to searching old patent applications and like engineering documents and textbooks. Those are things that don't have a lot of information about video games or like software. Oftentimes that's buried on someone's GitHub or like a wiki about a game, or
Hmm.
you have to look at the original source code. And you have very small people at the USPTO who are able to do that, but they're also time limited. So they don't really have the time to sit there and pour through database after database after database to find this stuff. So they just have a finding issue, and it's made more complicated by the fact that the words being used to describe stuff are so idiosyncratic and strange that they're beleaguered by it. They're like, oh, great, I don't know how to search this, right? Like, this is so convoluted, I don't know how to begin. And that's why you see sometimes these, I will call them give up allowances from the USPTO, where they go, fine, sure, this is so narrow and so specific. Just and part of that is I'm not trying to judge them. It's kind of their right because they do have a reasonable expectation that if this patent is actually valuable enough, someone's going to sue about it or someone's going to get sued by it, and then you'll defend
Hmm.
yourself. Or when IPRs were unavailable, you go to an IPR. So it was an option. It
Hmm.
was like an option.
Yeah.
We know that's not entirely the case, but it's reasonable for those examiners. They're working like dogs right now. They barely get the time they need to do stuff. So I feel kind of bad for them. They want to do better, but when they're presented, a 10-page long claim with all these weird terms in it that they can't search, and they know that probably there's something somewhere on somebody's GitHub that anticipates this, but they can't prove that because they don't have the time for that shit. They're like,
Hmm.
well, I guess the public's gonna have to handle it. I will do my best. I will do my legal best. If my supervisor says go for it, off we go. I'm trying, man. That's kind of how it
Yeah.
goes.
There's a level of leniency that has to be given with them, and anyone who's ever worked in the government understands that there is so much. There is so much, and with these, one solution I potentially thought like might be kind of good, but also has its own drawbacks. Is okay, they have this 12-month to 18-month time frame that they have to reach. 12 months with the extra 6 months under extreme or extenuating circumstances. If there was something that came out from the director, or a memorandum that came out, or an update to it came out that said like, hey, right now, given the time that what we're dealing with, we can extend that time frame even more. Maybe that would, at the very least, stop these cases where someone's gone and spent $500,000 in filing this and then gets it turned away
Yeah.
because we don't have time to deal with this. But again, then that could just quickly turn into something that's like, okay, we're gonna drag it out, drag it out, drag it out, and then we reach that settled expectations time frame, and now it's like, okay, well, they've had it for 5 years, they've had it for 9 years, they have settled expectations. Like, oh yeah, but we started this 9 years
Yeah.
ago,
Yeah.
so who knows? Um, and let's weigh in because you touched on one of the points of the database that we talked about earlier. But I'm gonna real quick go into. There's a lot of, and I've said that a lot of these patent claims are that for some of the Nintendo ones seem very general. There's 28 claims in one, 27 in another, 30 in one, 20 in another. I've become way too familiar with this, but also deeply understand that I do not have a legal background, so I'm familiar, I don't understand all the way. Um, and I try to reiterate that anytime I talk about it. And I've said repeatedly, I would love to talk to a patent lawyer. Um, with that, are these patents as complex as some are saying, or are they as simple as some are saying? If does it have to meet all 28 claims, or does it have to meet one claim, or does it have to meet some sort of preponderance of claims in order for the patent to go into effect, for it to be patent infringement if someone were to go on in a general concept with patents that have 10, 20, 30 claims assigned to them?
So all they have to show is one. However, it is kind of critical to realize that that has some interesting implications because there is a strategy to be raised with where, what you're asserting versus what you think someone's going to challenge. So let's say you have a standard, what's usually standard in the world of patents is 20 claims with three independent claims. Oftentimes, if you're strategically doing this correctly, you'll have a variety of dependent claims in there. So they depend from an independent claim, is all that really means. And they will describe different variants of your invention with different levels of fidelity. You can sue someone on a dependent claim. You can say, well, I'm suing you on claim four, which depends on claim one. And you might do that because it still covers what they're doing, albeit more specifically. And you believe that you are specific enough where someone cannot argue that what you were doing is not new. So you want to be narrow enough where you're defensible against what other people would call the prior art. At the same time, you want to be broad enough where you're able to sue someone and they can't get out of it or they can't design around it or a bunch of
Hmm.
other things. So it's a very delicate balancing act. Now,
Hmm.
what's interesting, however, is in the IPR world and just in the what we'll call the general invalidity world, what that means, because any of them can be used against you, is it typically behooves you to challenge all of them at the same time. So with an IPR, for example, when we prepare a petition, we would attack every single claim to the extent we could, because doing so means that no matter what, that whole patent's gone. Now, even if we lose on a dependent claim, so be it. If we don't practice that dependent claim, like maybe we're fine on that front
Hmm.
anyway. But the ideal goal is to make all of them go away. Because what can happen, and what has happened before with IPRs and everything else, is they'll say, well, independent claim one is invalid. However, dependent claim three is valid. And what that means is the patent may very well be only effective as to claim three. One is effectively toothless. And then you have a interesting question in your hands as to whether or not you practice claim three, for example. But notwithstanding that, the basic answer is when you want to get rid of something, you've got to basically go after all the claims if you want to be maximally defensible about it. The only
Hmm.
real exception I can see would be if it was so poorly written and so broken that no one in the world could possibly do it. In which, sure, fine, they can have it, man. Like,
Yeah.
if it's busted, I don't care.
Listen, they could do that. They're not coming after us for that. They want to patent a color. Sure,
Yeah,
go
have
ahead,
fun.
man.
Yeah.
It's great. I'll add a little bit different pigment into it. It's a different color. It's fine.
Yeah.
Um, okay, so it is very much like the fact that there's 30 claims. Any one of those individual claims. One of the arguments I've seen a lot as well. It's you see there's 30 claims here. It's so specific that unless you're meeting all those claims, that's not the case. If one claim in a patent is something that can be sued on,
Correct.
even
Just
if it
one.
doesn't meet the other 29. Do you think that's potentially another way that some of these patents that have 20, 30 claims, because I looked at some of the older ones too, they don't have nearly as many claims, 20, 30 claims, because the process becomes more expensive, both in the once you reach past 20 claims, it's another about $1,000 per claim that you want to add
Yeah.
to the patent office, which to a company is probably not a lot, but to me, Zachary Johnston, that's I don't want to spend that. Um, but then also because now they have to do more research, and that 250 to $500,000 limit might go to 550 or 600 because now they have to find the prior art and the reasoning for these 10 extra claims. You think it's potentially a way of doing lawfare, or is that just kind of the way the wind's going, the way the wind's blowing with patents? They're just having more claims attached to them.
It's a little bit of both. There are mechanisms by which the patent office tries to discourage people from filing a ton of claims. One of them is you'd actually pay for additional claims over the three independent 20 total. At the same time, they will force you to divide up your application into multiple, if, for example, you're claiming very different stuff in the same patent, right?
Hmm.
But realistically speaking, it is your intuition is correct. There is a value to having a patent with a ton of claims in it that is issued because if you have that, you're right. It's very difficult to challenge those with volume. And one really pragmatic but very big issue with IPRs is that there's a page limit and a word limit.
Hmm.
What that means is if they have 100 claims, that page limit, or rather, excuse me, it's a word limit, but really it's more or less the same, right? You know, column
Yeah.
A, column B. I think it's 1,400 words still. That's not a lot.
1,400
So
words.
you don't, or excuse me, 14,000 words, but nonetheless, that's
Okay,
not
that's
many.
yeah, I was
Because
about to
remember, you
say.
also got to quote the patent claims in there. So you don't
Yeah.
have that much left at that point. If you're talking about 100 patent claims, you're screwed. So you can do all these tricks to kind of put it together, and there's ways in which you can kind of explain to the patent office, look, this one's similar to this one, so we're going to address them together. But if you're dealing with a big one, that adds another stumbling block for
Hmm.
getting your ideas out there. And it's something that we've gotten very good at, just artistically speaking. But it's a massive stumbling block. And so again, you're paying a lot of money and you're paying extra money to address the other claims. And oh, by the way, you have to do so in the legal world, a very short document with an expert report. Maybe that expert says more and you can detail more in that report, but you can't do that much more. So it's really tough. And it is a way
Hmm.
to sort of inoculate yourself against major challenges. Not perfectly, but it does work a little bit.
I'll touch on a slightly separate thing. It's related, but it's slightly different. It's one of the questions I've been getting a lot, and I don't know why people are asking me this question because I don't know. I'm a military veteran with a biology background. I don't know why they think I'm the one to ask these questions. But I talk about it a lot. So, um, in the event that say a company is found to be fraudulently filing patents or it seems that they may be maliciously or intentionally filing patents for things that they know they shouldn't or just doing it in such abundance that there's no way that they don't know that what they're doing is wrong. Is there anything more than civil repercussion? Is there potentially criminal repercussion for either the CEO or the COO or the CLO or whoever's in charge of it, or for the sanctions be put on them? Is there more than just filing a PGR, IPR, and invalidating the patent? Is there some sort of punishment that these people might receive for doing so?
So unfortunately, the answer is yes and no. There, on one hand, there is, and fraud on the patent office exists where, for example, if I know for a fact that something else is out there and I don't tell the patent office about it, that's a very big issue. And there is a very good argument that can happen, right? If you, as an institution, are encouraging the filing of patents where you, as an institution, should know better, there's an argument to be made that that is a fraudulent filing to the patent office. Now, there's a lot of nuance there. Don't get me wrong. Like, how much do you actually know? Is it something that's printed out there, or something you actually are aware of, or is it just your kind of gut check? But the quintessential thing that you should never do as a patent attorney is file a patent application not disclosing, say, some potentially invalidating piece of prior art. Now,
Hmm.
I never do that, and there's a very easy answer why. If you want a strong patent, of course you tell them because you want to make sure that that stuff's neutered, right? Because if you cite
Hmm.
it and you ultimately get this patent allowed, that makes the patent all that much stronger because
They
you've
can't use that
had
against you.
exactly the patent office. Well, you can in some cases, but it's neutered, right? At most, you go look. The patent office considered this. They said it's fine. They said it's fine for XYZ. We're good to go. I love that because that gives it strength. However, if I were to not do that, that would be fraudulent, right? And it's
Hmm.
one issue that kind of scares patent attorneys is because we deal with so many patents and so many different references and things like that. We have to be very careful. We have entire systems for this. But to answer your bigger question, like, are they just doing it in volume and could they be punished for it? Possibly. I mean, one problem we have here with this entire system is it intentionally designed to be a form of monopoly, right? Bluntly stated, it is the best legal form of monopoly you can get. So there are aspects of it that look a lot like what might be perceived as an antitrust violation that are part of the system and intended to be part of the system. That's good. We like it. But it looks skeevy and you get a bad reputation and people tend to hate you for it. There are rumors that there will be changes along this front because we want to encourage legitimate innovation. At the same time, everyone knows what a patent troll is now. It's become a household term because these folks
Hmm.
have come out of the woodwork. They lost in the technology sphere for one reason or another, and they came out like shambling zombies to sue everyone who was successful. I dealt a lot of my earlier career dealing with those folks because they would come out of nowhere with some patent from a long dead company that they had purchased, and they would sue your pants off for it because they just wanted money.
Hmm.
And there's an open question as to whether or not the same thing is a concern when you have major corporations leveraging their knowledge of patent office busyness, inability to search, time limitations in order to force down patent applications that they arguably know shouldn't be allowed. Now, I wouldn't impugn that hard when I think Nintendo's doing a lot of mistakes. I don't necessarily think that they are being outright fraudulent, at least as far as the facts that are available to me now. As far as I know, they are taking advantage of the system in a way that we might not like and that is very embarrassing, but at the same time is, unfortunately something they figured out how to do. And there isn't, to my knowledge, a direct law against just being a really crappy company.
If there was a direct law against being a shady company, there
They all
would
be
be
gone.
no companies. It's done. It's gone
We're all gone, yeah.
forever. Yeah. Um, and so theoretically, yes, but practically, no, especially when it comes to the concept of you have to prove that they knew what they were doing or should have known what they were doing. And it's not always easy to do, especially with that. With that, that kind of goes into another question I had, and something that came up very frequently, especially with some of the recent news has come out and some of the recent statements people have made. You started your legal practice in Japan, or you started your practice of law in
Yeah.
Japan, your legal career in Japan. Is there a culture within Japan of one, the big guy is right and the little guy is wrong? And two, is there a culture of, because it's almost the opposite in the United States. In the United States, if you can have someone do something horrible to a big company and people are going to be like, yeah, yeah, good job, guys. Whereas from what I'm seeing, or at least some of the comments I'm getting, it seems like it's kind of the opposite. Or there's might also be a culture of if you are being sued, you're wrong until you prove that you're not. Um,
There certainly is that to some degree. So, in my limited experience, and granted, there's a lot of nuance here that's cross-cultural
mhm,
and things like that. You're right. There is a domain in which, in this, you actually honestly see this out of a lot of smaller economies with their domestic, homegrown companies. They don't want to shoot their own people in the foot, especially when it's someone who is sort of integral to your culture, your country, your domain, where they are purporting to have something new or purporting to be in the right. There is a lot of pressure against that. So you see that in Japan, you see that in Korea, you see that in China. Honestly, you see that to some degree in the United States. We play favorites.
mhm,
And it's fair to some degree because we kind of have to, right? Like there's a fair
yeah,
argument to be made that hell, America has this, I mentioned earlier, this process called the ITC, where we especially explicitly have a system for American companies with patents to prevent importation of other stuff for their US patents because we want to
mm,
protect American companies. So we're all kind of doing that. However, it is fair to be said that in Japan, they are very good at patent prosecution. Whenever I've dealt with them in any form or fashion, they have some very good examiners, they have some very good processes in place. They're
mhm,
fantastic. However, one cannot escape the assumption that they are slightly biased in favor of hometown, homegrown folks.
mhm,
There are plenty of companies competing with Nintendo who are Japanese as well. But the blunt reality of it is that Nintendo is a household name that's from Japan. It is a star of Japan, much like Sony is, or Konami, or any of the other ones. It's hard, I imagine, to tell them no. And it's hard, I imagine, to inherently assume that if they have a valid and granted Japanese patent, that if they sue you on it, that they are not slightly biased in, or the court rather would not be ever so slightly biased in favor of them. Now that's speculation, right? The ideal situation that it's fair. Realistically, do you really want to be telling one of Japan's most famous companies, no, you're wrong about your granted patent? That's a tough hurdle.
yeah. Well, with that, I think I've reached all the main questions I have here. Now, one of the questions I want to ask you, and this is self-serving, obviously, but how would I've spoken to you and you've suggested independently about the database I want to start, a
Yeah.
prior art database that will be encompassing of not just the ideas, but every potential implementation of an idea. So let's say we have a fishing mechanic. It won't just be like, here's the earliest example of a fishing mechanic. It'll be like,
Yeah.
this is fishing in this game, and this is how it works. And this is fishing in this game, and this is how it works because it's slightly different. And as many possible examples of that as there could be, encompassing all the different sorts of mechanics in video games. It'll start as a video game one, and then hopefully move into just other forms of artistic expression if I can get enough weight behind it and enough time and enough manpower behind it, because this is going to be a very
It's a lot of work, yeah.
yeah, it is. The data entry
Oh,
alone.
yeah.
Let's just disregard the research. The data entry alone. Um, how would you see that being effective? Obviously, it's something you think is a good idea. You suggest it independently to me. Uh, how will that affect one ongoing lawsuits that there might be, as well as the patent office going forward, or at least the USPTO going forward, when it comes to people filing as patents. That you said previously that they don't really have a database that they can access that has these sorts of prior art. So they're kind of limited in the research that they can do, especially on the time frame that they're operating on. Do you think this will be helpful? Is this, or how will it be helpful rather? How will it be helpful both in the case of ongoing lawsuits and in the future to prevent quote unquote patent trolling with people trying to get patents for things that maybe they shouldn't?
So there's a few dimensions to it. I'll kind of start with the pragmatic stuff. So on one hand, to do it correctly, I think that there's really two major requirements that I think would really need to be met.
You're cutting out. Hold on.
Let's see. Does that work now?
There you go. That's much better.
Yeah, I wonder what happened. Like, I think my little cord here is going on the fritz. All right. Anyway, there's two base requirements. One of them would be at a very high level, you want to ensure that every single claim limitation, every single word is met literally. So one issue with a lot of folks who want to help out in this situation is that it's very difficult not to just assume that something's taught because it's something similar that you see and you know about. Unfortunately, with patent claims, every single word has to be met, and you have to break it down with that level of granularity. That is tough. The other side of it is, and this is perhaps the more difficult one, is that you would have to prove that it was something that was published or available prior to the filing of the application. So it's not when that patent was granted, it's not when the patent was found out by someone or when they sued. It is the original filing date, which oftentimes can be quite some years ago. So the ideal situation would be a database that correlates, say, word level or sort of phrase level context to these claims, along with proof from archive.org or public code databases, repositories, games, whatever. It doesn't have to be perfect. Like, I realize that it can be tough to prove some of this because these games,
Mhm.
it's not like
Mhm.
developers were just putting out their code bases and they sure as hell
No.
weren't detailing this stuff. But if you can identify it with specificity, oftentimes lawyers can do the rest, and we can even hire professional law librarians to go find copies and things like that. But more broadly, let me kind of zoom out a little bit and say the utility of this thing would be twofold. One of them would be for active threats from those patents would effectively be neutered if this database was accurate enough, right? And there are folks who have bandied about lists like this before for including these Nintendo patents, is that they have ideas of kind of what's out there and what they would use if it really got bad. So there are lists like this, but they're not perfect. And having something like that public would make it way easier for small guys if they ever got threatened by this to go, well, there's a website I can just go to and find this stuff for free.
Mhm.
On the other side, future looking defensibility, it's tough because in some ways you'd have to guess what companies like Nintendo would file in the future. And by definition, they have to file something that they think is new. So it can't be something similar to what they've done before. But the nice thing is, if you do this correctly, it's going to make it far harder for what they call continuation applications. So when I file a first patent application, I can, for example, prosecute it, I can get an allowance, but I can also, before the grant of that original, I can spin off what is called a continuation application. So I can get another patent on the same disclosure with the same filing date. And that's what often Nintendo and pretty much every other company does because you might have multiple ideas in the same application. It's a fair practice, everyone does it. But if they have a bunch of applications waiting in the wings about to be allowed and they're debating whether to file a continuation, they might be inhibited if there's a massive damn database out there saying how bad of an idea the thing was in the first place, because that's going to
Mhm.
strongly limit their ability to get a continuation, and it probably will limit their ability to get an allowance of the very first application if you hit the right targets. Candidly, it's going to be tough, but one of the best ways to do about this would be to say, on one hand, you would want a list of applications, or rather, pending applications that are published. So they would be patent publications. That doesn't mean they're granted. It just means it's an application that's been published after 16 months from filing. So 16 months after, you'd see it pop up. You'd have the first version of the claims they filed. That would start a gun for you to try to describe why what's in there is not new. The other side of it would be any granted patents, that is, US patent number XYZ. That's the kind of stuff that you could go after to ensure no continuation applications and
Mhm.
to make it far harder for them to sue on those because you'd be giving everyone the war chest of what would need to be out there. So there's multiple dimensions to how useful this would be. But like you said, it's a hell of a lot of work. It's something we call in the industry claim charting. It is, we do it all the time. It's part of our practice.
Mhm.
It's time consuming as hell. It is
Mhm.
really hard work. So it would be, a valuable thing to do, but boy, it's a high lift. And I
Yep.
remember talking to you originally on the phone. If you're gonna spend any money on something like that, that would be the value. As
Mhm.
tough as that is, that there's value to that immediately.
Yep. And my goal is to eventually have a GoFundMe going that is to try to hire it so I can at least hire one guy to work for me, one guy to make the website, and then pay for the database, and then hopefully show that it's useful enough and be able to get a demo out there of like, hey, this is for this set of stuff, looking like specifically at the Nintendo patents first. See, this is what we can do. Please give us more money. Please help.
Yeah,
Because
it's
this is
good.
gonna die once I can't host it anymore, kind of thing. But with that, so you're saying one of the best ways to go about this might be to look at patent claims. Start by looking at patents that we think maybe should be devalidated or we're worried about lawsuits in the future. Target those and go claim by claim, and then expand to maybe things that aren't there yet, or mechanics that aren't there yet, or aren't being litigated right now, or whatever. And then start expanding from there.
Yep, yep.
One of the
And
things, yeah, go on.
oh, and one magical thing about this is there's a fun dimension to this, right? Like it doesn't necessarily have to be just defensive. There's value to cataloging the history of a lot of these mechanics because, for example, if we're talking mounts, I mean that's been around. I kept joking with one of my colleagues. We don't really quite remember. At least one of the early Ultima games for DOS had this sort of thing. So there's
Yeah,
a
yeah,
long progeny of this stuff that would be kind of interesting to think about because I just it's not
yeah.
something a lot of us think about. It's like this is we've been developing different forms of mounts for a very long time. Uh,
Well, I mean, your one previous statement in a previous interview said you used a D&D character sheet.
yep, yep.
In my D&D campaign right now, one of the players has a dog that they're a halfling. They have a big dog that they're using as a mount. That's been around for a while. They've had horses in D&D for a while, so the concept of a mount in gaming has existed.
Yeah,
It might not have been on a three-dimensional plane and blah 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 for until Guild Wars maybe, or EverQuest, or whichever one decided to do it first, but it's been there.
absolutely. Like it doesn't have to be perfect. I mean, there is thankfully a understanding that a what we call a person of ordinary skill in the art
Mhm.
is they're smart, right? They can see what's out there already and put things together. And especially
Yeah,
game developers, that's what you do. You
yeah,
mishmash different conceptual concepts from games that you liked, and you come up
yeah,
with something you like even better. So it doesn't have to be like all in one game. It's just that
yeah.
we've been working on this stuff for a while. It's been around. A lot of RPGs, like you intimated, they have been based on D&D or some form of tabletop role playing because
Mhm.
that's what those developers were playing when they made those games. So,
Mhm.
it's all one big continuum.
Yeah, art very rarely comes out of a vacuum. It's
Exactly.
usually a combination of experiences that you've had throughout your life that have created something new,
Right.
but derivative.
Right.
And there's nothing wrong with being derivative. That's life is derivative. That's I'm a biology major. Life is derivative.
Everything's
It started with
derivative.
yeah. It's that's how it works. And just I guess getting a little guidance here on this. The way I'm thinking of doing it, and would this be helpful, is it will be a searchable database, but also a filterable database. So it'll have mechanics listed out and filterable by multiple potential filters. So it'll have mechanics listed out. You could type in this, and this is what I want to see, or you can filter with creature mechanics, capture mechanics,
Yeah.
battle mechanics, PvP, multiplayer, and add all those filters, and then every single game that has been reviewed or every single mechanic that has been reviewed will have those tags attached to it so that you might be looking for a very specific multiplayer fishing game with PvP elements that is 3D that has mounts.
Yeah.
And then you might each one of those individually might have 100 examples, but when you get down to it, there's five.
Yeah.
When you have those five things, one of the ways I'm thinking of approaching it, and then laying down the description in layman's terms, so the average person can in a step by step, like, okay, to fish, create fishing rod, press button, fish bobber goes in or sinker goes into water, sinker shakes, click sinker, a random determination of what fish you caught, but also trying to lay it down. And I want to get potentially like a paralegal involved in this so that they can do legal terminology, and a game dev involved in this so that they can do techie terminology, but break it down in those three sorts of ways: that layman, tech person, legal person, and then have a video attached to each one that shows, like, I'm going to have my team go and get the videos of the ones that they can. Probably not use emulators because then it's going to get
Uh,
copyright struck and blah blah blah. But for the ones that we can, get video that shows it, so that, okay, now even if the three ways that we wrote it are not the right way to write it, the lawyer involved has ready access to it, and they could rewrite it in the way that needs to be written.
Absolutely. Yeah, that technical explanation would be particularly valuable because, usually lawyers can figure out how to characterize it in precisely the right way. So sometimes it's like, there's an art to that. Who cares? But the technical side of that, especially, that's valuable because really, in some ways, what you're describing emphasizes the modularity of a lot of these game mechanics, which is incredibly important to showing, when you're a game dev, this is not something where you're forced down a singular path. Like I picked Metroidvania and this is how I must do it. Like we all have ordinary creativity. We can do these
Yeah,
things.
yeah.
So as a consequence of which, that's fantastic. That shows that people in your shoes have the ordinary ability to mash stuff together into different genres, games, styles, whatever.
Hmm.
And it's all within the ambit of what we would do if we wanted to make the game like that.
Hmm.
It's a this creative decision that's inconsequentially easy in some cases.
Yeah. I mean, look at let's give an example of that kind of concept of Five Nights at Freddy's. Five
Yeah.
Nights at Freddy's was made in Click Team Fusion.
Yeah.
Click Team Fusion is a mesh-based software. He wasn't writing code; he was using pre-designed code, putting it in a block, and coming up with a unique outcome that defined a genre.
Yep.
It was something that hadn't been done quite that way before. It was. I'm sure you could find prior art that shows something that you could have someone argue. Well, technically, a game like this has existed before, but it was unique enough and it was new enough that it defined the genre.
Right.
And that was based on concepts that someone else had designed and put into a drag and drop database, effectively, which was Click Team Fusion.
Yep.
So it's yeah. Yeah, that kind of I don't know what else to say about that, but yeah, it's
No, you're right. I mean, think about it. Like, what is it? RPG Maker, Game Maker Studio, and a bunch
Mhm,
of other ones. They've been around forever. Like,
mhm,
hell, there was an RPG Maker, I think, for the DOS at some point. I discovered this recently, which amazes the hell out of me. But this is something this industry is like that, right? We
mhm.
are very good at iterating on each other's stuff, and it's all been improvements. Like, I'm for certain kinds of game patents because I have seen plenty of innovations, like in graphics processing, for example, like those old school John Carmack style inventions. Like, yeah, okay, you're the first person to discover this incredibly complicated way of
Mhm.
rendering. Sure.
Yeah,
But at the same time, there is a domain of this where it's kind of like writing. You're riffing off
yeah,
each other. You're standing on the
yeah.
shoulders of giants, as some lawyers say.
And I'm probably gonna lose a few subscribers over this. I am pro IP as a concept. I know there's a lot of people right now that say, "Oh, IP is bad and copyright is bad." It's like, to my mind, and get in my comments. If you don't believe that IP is good, if you don't believe that the concept of copyright is good, you are displaying a remarkable lack of creativity and motivation. Because the only reason you think that is because you are incapable of creativity and motivation, or are offended by the fact that other people got to something first. I remember my dad ranting one time when I was younger about how, oh, they only used to have skates that were, the four
Oh
wheels
yeah.
side by side that kept you up, and then he used to take his skates and modify them into inline skates, and damn, he should have patented that because like, okay, but someone got to it first, man.
Yeah.
Sorry. But like I worked or I did research in a regenerative medicine lab, and that is a prohibitively expensive field to do research in. So without patents, without some sort of protection on the new, we call them medical devices, the medical devices that are being created, there's no motivation to do it.
Right.
So there's no research going into it. So there's no money going into it. So it's not going to happen because if these companies that are funding it can't protect their right to make a profit, I think in the medical field it's 15 years as opposed to 25. But if they can't make their 15 years of profit on it, they have no reason to do it because unfortunately, as much goodwill as we want to have out there and as much as we want to stand up for what's right and do what's right, money makes the world go round. And these things cost money to do. I mean, a pair of gloves a pair of surgical gloves cost $1,000 and you can use them once. It's
Yeah.
insane. So I'm very pro IP with that, and I think it's an important thing to have. So you saying, yeah, if there's something's innovative enough, absolutely, obviously, yeah. It's someone put the effort and the time into creating this thing, so they deserve to make their money back on that, and then some, and make a profit off of it, because otherwise they won't do it.
Right. Right.
Um, but with that, I don't think I have any other questions to ask. Is there any closing statement that you would like to make?
Not a bit. I'm always happy to talk about these things. I mean, I know this is a complicated area, but I'm excited to hear about y'all doing this project because this is something that
Yep.
let's put it this way: other IP lawyers have been talking about wishing that the games industry would do this for a while, if you catch my drift. So
Yeah,
I was
I
recently at a games, goodness, the Video Game Bar Association meetings, and people were joking about
yep,
that. Like, why don't they just begin to document this better? It'd be better for everyone. So
yeah.
you're really doing good work. There are people who are extremely excited about this. I've already told a few IP attorneys who are in certain companies that this is in progress and they are extremely excited. So
Okay.
it's a very cool
Yep.
project.
Yeah, and if there's anything that you would like to see, like in it, like I would love to get the feedback from IP attorneys, especially of what sort of functionality they would like to see in this database, because the more functionality I can add, the better. And there is a part of me that's like, okay, I need to make it in some way profitable,
Right.
so that it can maintain itself, so it's not always trying to ride on goodwill. I mean, if you ever go on Wikipedia at any given time of the year, you see the sign like, "We're sorry to ask again. Please, please, for the love of God, give us
Yeah,
money."
Jimmy Wales wants his money. Yeah.
Yeah, I would like to not have to do that. So there's some things I'm thinking like, okay, well, I can add this extra bit of functionality or something, and maybe put that behind a paywall that for law firms or something like that for the or what. But I don't want to do that. I want it to be publicly available. So I'm trying to find the best way to make this a thing that can survive on its own 2 feet, but have as much functionality as possible so that the little guy can stand up
Right.
and defend themselves. So again, any sort of feedback that you have on any sort of functionality or any sort of thing that you want in there, let me know.
Oh yeah, there will be plenty of
I will
us
add
having
it.
opinions. I want to send so many opinions. It's gonna be annoying after a while, I promise.
Oh, it's fine. I'll have my girlfriend read them or something. Okay. Well, thank you for this opportunity. It's been great. I'm happy that we were able to talk about this, and I look forward to potentially talking to you again in the future.
Cool. All right. Well, thank you so much for your time. I really do appreciate it.
If you've made it this far, please consider commenting, liking, hyping, or subscribing if you haven't already. Every bit of engagement on this video will help it do a lot better, help it get a lot more reach, and just make the channel take off a little bit more. If you would like to help me in my personal fight against patent trolling and against Nintendo, please consider donating to my GoFundMe to help me build a database of video game mechanics and prior art for those video game mechanics that can be used by both indie firms, indie developers, and law firms when they are fighting against patent trolling cases. They'll be able to easily access all the prior art for those video game mechanics that they might be being sued for, as well as hopefully be used by the USPTO in order to prevent them from granting patents for things like video game mechanics that have already existed in the past that they just have a lot of trouble finding. If you want to help me on a more personal level, then consider clicking on that playlist over there that has it's a playlist of my storytelling channel and has a bunch of the different stories from like my time in the military, personal things that happened in my life, or the time that I got pepper sprayed. It's a lot of fun for me to like tell these stories and have people relate to them and react to them and think they're funny, or whatever they get out of them. It's a very cathartic thing for me to do. So I'm hoping that channel takes off a little bit more. But with that, thank you. Goodbye.